Good morning, everyone, and welcome to today's webinar, Mastering Mortgage Enforcement Strategies for Lenders and Borrowers. I'm Mayela Jami from ME Law, and I'm thrilled really to be diving into this topic of paramount importance for really for anyone that's involved in mortgage transactions, whether you're a lender, borrower, or legal professional. Times are tough these days. As you have seen lately in the news, Ontario's mortgage delinquency rate has nearly doubled, in the last year as higher borrowing costs continue to put homeowners under strain. A latest Equifax report states that more than 11,000 Ontario mortgages recorded a missed payment in the final quarter of 2024. This is 3 times the number recorded just 2 years ago. This is a big area where I can go and really spend all day talking about, including going into a deep discussion about, for example, the doctrine of unconscionability, Unconscionable Transaction Relief Act, unequal bargaining power, and so forth. In the world of real estate and mortgage finance, enforcements can be really complex and a high-stakes issue. From missed payments to foreclosures, the outcomes of enforcement can have long-term effects on both the financial landscape and personal lives. Whether you're lending money or you're managing your own mortgage, really understanding the legal implications and the process is crucial. Mortgage enforcement directly impacts both lenders and borrowers. And today a session, I'll give you the knowledge you need to navigate the process effectively. You'll walk away with key insights and strategies for protecting your interests during the mortgage enforcement process, as well as clear understanding of the legal frameworks governing this process in Canada. Now, we're going to take a quick look at today's agenda. I'm going to start off by helping you understand what mortgage enforcement is and why it matters for both lenders and borrowers. We'll then turn and break down the legal framework that governs mortgage enforcement in Canada, with a special focus on Ontario and British Columbia. And you'll later find out why we're focusing on Ontario and British Columbia. And, we'll discuss the proactive measures lenders can take to protect themselves and early warning signs that borrowers should be aware of. We'll look at what happens when enforcement doesn't go as planned. We'll cover how to handle shortfalls and explore legal strategies. And then we'll also explore a little bit about alternative dispute resolution when enforcement disputes arise. We'll talk a little bit about mediation, arbitration, and so forth. At the end of our session, I'll take a few questions in our Q&A session at the end of the webinar. You can post those questions on our chat there. This will be up on YouTube. You'll have access to it if you want to go back and kind of take your time to go through the slides. It'll be available for you to do so. Now that I've introduced the topic, I want to dive deeper into the legal framework governing mortgage enforcement in Canada. You have to, this is a process and you need to understand it, You need to understand the rights and obligations that come with mortgage enforcement and the importance of that for both the lenders and the borrowers. Mortgage enforcement in Canada is primarily a provincial matter. While federal laws government handle general aspects of trade, commerce, banking, and bankruptcy, the specifics of mortgage enforcement are regulated by provincial laws. This means that Ontario and British Columbia have distinct processes for mortgage enforcement, each with its own legal framework. These processes are also similar, and I'll explain how. In Ontario, the primary legislation for mortgage enforcement is the Mortgage Act, among other acts that you can rely on. This act lays out the rights and obligations for both the lenders and borrowers. Lenders in Ontario have the option to pursue either the power of sale and or foreclosure, but the power of sale in Ontario is often the method of choice. This option does allow lenders to sell the property without involving the courts, provided that the borrower has been notified and a reasonable opportunity to rectify the default has been given to the borrower. Another thing is that if you do a notice of sale, borrowers can contest that as well. So you need to be aware that you could eventually end up in court. In Ontario, the power of sale process involves limited, as I mentioned, court involvement compared to foreclosure, and here is how it works. The lender must wait at least 15 days after default occurs before sending out a notice of sale. The reason why you must wait 15 days as a lender is because sometimes the money is in transit, right? Sometimes, the banks are delayed. Sometimes, the money, it takes a little bit of a while to clear. So as both a private lender and an institutional lender, you need to follow that 15-day waiting period. Once the 15 days, have surpassed, then the lender must issue a notice of sale to the borrower, providing the borrower a minimum of 35 days, again, to pay their arrears, Again, this is giving the borrower the chance to rectify the situation. Generally, the process does not require court approval unless the borrower challenges the sale or there are disputes, And I'm going to be referring to I'm going to be providing a case later that I recommend everyone that's both a borrower and a lender review the case. It really is, it involves all aspects of mortgage lending and the basically the relationship between the parties. During the notice period, as I mentioned, the borrower can redeem the mortgage by paying the outstanding amount. If the borrower does not redeem, the lender can then proceed with selling the property. The sale must be conducted fairly, and the lender must act in good faith to obtain a reasonable price. And I would go even further and suggest that the lender must ensure that they basically keep all the steps they've taken to, let's say, for example, appraise the property, market it at a high price, offers that were given, offers that were accepted, etc. Because later on, when you're trying to go, for a deficiency judgment, you want to be able to have that evidence. After the sale, the proceeds are used to pay off the mortgage debt, with the surplus returning to the borrower. As I mentioned, if there's a deficiency, the lender can pursue a deficiency judgment through the courts, and this is often the case if there's 1, 2, 3, 4 lenders on title to a property, whether it's residential, commercial, or the facts are require that. So it really depends on the facts, I did mention there is limited court involvement, but lenders issue a notice of sale and sometimes a statement of claim together, This is can be a strategic approach, and it really depends on your facts. And the reason why this is a strategic approach, because it combines both actions and it can streamline the enforcement process, allowing the lender to pursue multiple remedies simultaneously. Another area of why it's usually the lenders will combine these two things is because it can encourage borrowers to address the default more promptly, knowing that the lender is pursuing all available legal options. It also is basically, it ensures that the lender is prepared to proceed with either power of sale or foreclosure, depending on how the situation unfolds, and it's very flexible. As the most cost-effective method of enforcement, as circumstances do change. Like I said, a borrower can go in and contest the notice of sale. By taking both actions, lenders can effectively manage the enforcement process and really protect their interest. At the end of the day, you want to protect your interest as a lender, and you also want to ensure that you're protected against claims the borrower can make. Now, I'm going to turn and look at foreclosure, which is another area where you can enforce a mortgage. It is less common in Ontario, but it can still be pursued if the power of sale is not viable. It's a more formal process where the lender must go to court or obtain a judgment before selling the property. Okay, now this process also allows a lender to basically take complete ownership of the property, okay, because the borrower failed to meet mortgage obligations. It's a super court supervised process, okay, and once you get the final order, the borrower's rights to the property is completely extinguished, okay? Now, the steps that are involved in this is, first, the borrower fails to make mortgage payments, so they go into default, triggering the foreclosure process. The lender files a statement of claim in court to start the foreclosure proceeding. The court may set a redemption period, allowing the borrower time to pay the arrears and stop the foreclosure. This comes in a preliminary order called the order nisi, okay? It would include also terms of the foreclosure, including the length of the redemption period. If the borrower fails to redeem, the court issues an order absolute, basically transferring property ownership to the lender. Okay, the lender then takes possession of the property to sell it and to recover the debt. Again, the borrower has opportunity to basically make payments and bring either their mortgage up to good standing or basically to redeem. So it's not just that the lender is going and doing all these things, right? You're giving the opportunity to the borrower. Now, if in Ontario, mortgage enforcement, as I mentioned, is quicker and more straightforward with the power of sale process, lenders have an advantage because they can proceed with going to court. So you have to make sure that you're not, there is no unequal bargaining power, because that can come up in court and it won't look good if you as a lender, a finding is made against you that you have more leverage, okay? However, lenders must be cautious with the timelines and documentations, okay? Section 32 of the Mortgage Act states, okay, where a mortgage by its term confers a power of sale upon a certain default, notice of exercising the power of sale shall not be given until the default has occurred for at least 15 days, and the sale shall not be made for at least 35 days after the notice has been given. And as I explained in simple terms, the lender must wait at least 15 days after the borrower defaults. It's okay if you wait longer than that before proceeding with the sale, the power of sale. The reason why I am saying that it's okay to wait longer than that, because you want to come to court with clean hands, okay? This is a statutory framework, and it's found under Section 32 of the Mortgage Act, okay? If you come to court with clean hands and you show as a lender, okay, that you've been assisting the borrower in trying to help them, you're understanding the situation, you're most likely going to be successful, okay? If the borrower does not pay the debt within the given time, again, the lender proceeds. There are several safeguards during this period, including the right to redeem the mortgage for the borrower, paying off the debt in full before the sale is complete. Okay, and I've added what the right to redeem is there. If you don't, if you are a borrower and you don't know what it means, it's a legal right to reclaim the property by paying off the full mortgage debt, including any associated costs and interest, before the power of sale or foreclosure is finalized. This right allows the borrower to prevent the loss of their property by settling the outstanding obligations. Okay, it is a crucial protection for you as a borrower. Okay, so you as a borrower have to take the steps. Okay, you have to communicate and so forth with the lender, but I will explain that a little later on in our webinar. Okay, now in British Columbia, mortgage enforcement is more often pursued through foreclosure. Okay, especially when the borrower cannot repay the loan. The Law and Equity Act, BC's Law Title Act, and BC's Property Law Act govern this process. Okay, the foreclosure in BC requires judicial approval. It can be lengthy. Okay, it does give the borrower more protection, and it involves the court who gets involved if the borrower is challenging the sale. Okay, and it can take us several months or longer, really depending on the complexity of the case. However, because it involves the court, there's more oversight, right? So there's no issue of having to fight over whether you as a lender have the right to sell the property or go through the whole foreclosure. You can use in BC the power of sale, but in certain situations, but it really depends on the terms of your mortgage agreement. Okay, as I mentioned, it can take several months. It is generally more costly because it involves court fees, legal costs for filing what they call the petition, which we refer to in Ontario as the application, and potential expenses for maintaining the property while awaiting the court's decision, and really the lender's responsible for the legal costs in pursuing this case. Okay, it's we're going to turn now to look to see. This is the same. Order nisi is the same in Ontario as it is in BC. Okay, I just broke it down here for that. It's to help you understand more how it works and what it means. It is a preliminary order. Okay, it does set a deadline for the borrower to pay the outstanding mortgage debt to avoid the foreclosure. Okay, it establishes the redemption period. Typically in BC, this lasts at least 6 months. Okay, but the court can adjust the period based on the circumstances of the parties. Okay, if the borrower fails to redeem within the specified time that is in the order nisi, the lender can then seek an order absolute and take possession of the property. It is a crucial step, but it is, as you can see, it's pretty straightforward, the process. But again, you have to be aware that, it really depends on your circumstances as a lender and borrower. It really depends on your facts. Okay? And then again, I broke down what order absolute means, its purpose, the implication for the borrowers. Basically, you'll lose all the rights of the property. You cannot reclaim the property once the order absolute is granted. Then the lender gains full ownership. They sell the property, recover the debt. The lender then can may still pursue a deficiency judgment. Okay, if the property sale does not cover the outstanding mortgage balance, and it marks the end of the foreclosure process. Okay. Again, as I mentioned, borrowers can still pursue a power of sale in certain situations depending on the terms of the mortgage agreement. It does allow the lender, again, to sell the property without court intervention, generally faster, less expensive. Again, you still have to follow the statutory requirements. So you could see that's very almost similar in a sense where how in both provinces it's almost similar in terms of how you can enforce, how you can do mortgage enforcement. But in British Columbia, foreclosure is often the route taken by lenders. Now, to summarize, foreclosure requires more court involvement. Okay, in foreclosure, the lender gains ownership, while in power of sale, the property is just sold to a third party. Foreclosure is typically more time-consuming and costly, and it's less common it's less common in Ontario than the power of sale. Okay. Let's move on here. So what avenue to take, right? So you might ask yourself as a lender, what avenue should you take? Okay. Lenders often want to choose based on speed and cost effectiveness of the process. Okay. The borrower usually wants protection. So they want more opportunities to contest and redeem. Okay. Borrowers, again, if there's deficiency judgments, borrowers may still be liable for any shortfall, right? So, it really depends, okay? It depends on the statutes. It depends on the facts, right? It depends on the relationship and the facts of the parties. Like how did you as a lender deal with the defaulting borrower, right? What was the borrower's response? Was the borrower more open and communicative in terms of their financial well-being, right? So you also have to look at the contracts. You also have to look at the priority. Are you a first, second, or third mortgage? Okay. The key difference, again, is the court involvement, okay? It's more faster and straightforward, okay? Common challenges, okay? Now we're going to look, now having examined the key difference between mortgage enforcement methods in Ontario and British Columbia, it is clear that while the frameworks vary, both lenders and borrowers do actually face unique challenges throughout the mortgage enforcement process, okay? And now I'm going to focus on some of the common challenges faced by both the lenders and borrowers, okay? These challenges really go beyond the legal mechanics and touch on financial, reputational, and practical aspects, okay? One major challenge for lenders is really ensuring that you're complying with strict legal requirements, okay? So in Ontario, lenders must follow precise timelines for sending notices and granting the borrower a chance to remedy the default, okay? Failing to meet those requirements can delay the process or even invalidate the sale. Another challenge for lenders is the risk of deficiency judgments. In cases where the sale of the property does not cover the full amount of the outstanding mortgage, the lender may pursue the borrower for the remaining balance. This is where you need to understand the difference between foreclosure and power of sale and the options that you need to, that are available for you to recover the balance, which can differ, okay? Now, lenders, what are the common challenges faced by lenders when they're pursuing a default deficiency judgment really starts first. The process of obtaining a deficiency judgment involves court proceedings. It can be expensive and time-consuming. Second, if the borrower is insolvent or declares bankruptcy, recovering the deficiency may be difficult or impossible. Third, pursuing a deficiency judgment can harm your reputation as a lender, especially if you're perceived as aggressive or unfair. And fourth, even with a judgment, collecting the debt can be challenging if the borrower has limited assets. And finally, there could be fluctuations in property values, what we're seeing now with the market conditions. This can really, affect the amount recoverable through a deficiency judgment, okay? Now, early warning signs and risk management for lenders. For lenders, managing risk proactively is just as important as recognizing potential borrower distress. There are a number of steps lenders can take to really mitigate the risk of mortgage default and minimize the need for enforcement, and also protect the lender from mortgage fraud, okay? If the borrower is committing mortgage fraud, the lender should be taking on additional steps, because the last thing you want is you're being sued as part of a mortgage fraud scheme as a lender, okay? Now, you should do thorough credit checks, and you need to understand, you need to understand the borrower's financial situation, okay? You need to assess the likelihood of the borrower defaulting in the future. This would involve evaluating income, debts, and financial stability. You need to take this step. By doing that, you can evaluate the borrower's creditworthiness, okay? You need to verify income. So you need to verify that this person is actually working at this place, that they're saying they're working and making that much money. They're saying they're making that much money. You should also, as a lender, you should be spreading your risk by diversifying your loan portfolios across different sectors and geographical areas. There should be a robust underwriting standards and criteria implemented, okay, to ensure that loans are actually be given to qualified borrowers. You should also set up, if you're a private lender, you should really set up regular monitoring of payments, right? So this can help you spot any missed payments of the borrowers earlier, giving the borrower an opportunity to address the issue before it really becomes a larger problem. You can use tracking tools or hire a third-party service to monitor the borrower's account with you, okay? Other areas that you should look to as a lender. You should create really flexible repayment plans. For borrowers facing temporary financial difficulties, you can offer them temporary forbearance, or you can offer them flexible payment plans to really help keep them on track. Okay, this flexibility can really prevent defaults and really reduce the need for costly enforcement process. So you as a lender need to determine the early warning signs. Okay, you also as a lender, you should have early communication with your borrower. Okay, you need to establish early communication with your borrower or with your borrowers when payments are missed or financial difficulties arise or changes in the market conditions. You should really contact the borrower immediately to understand whether the market conditions are affecting them personally and really offer them potential solutions. Whether that means restructuring the loan or providing them additional resources. If you take that proactive steps, again, you're going to come to court with clean hands. Okay, if issues arise down the road. Other things you should look at really is risk-based pricing. Okay, maintain conservative loan to value ratios. Another big thing is you need security for the loan. So you need to be given where you're given adequate collateral to reduce any potential losses. So for example, if someone has a house, okay, and they're purchasing another house, or they have a commercial, building and they're purchasing another commercial building, and that the first property they have is mortgage free, you can put on some collateral on that when you're providing them with financing. Okay, now we're going to look at the common challenges faced by borrowers. Now, if the borrower, the biggest concern borrowers face really is the risk of losing their property, okay, through the power of sale or the foreclosure process. And once the property is sold, you can't recover it, okay? You can't go after the innocent buyer. You can't, I understand it is a significant personal issue, but you really can't go after people who had no involvement in this, okay? There's also the challenges that borrowers face in trying to come up with the funds to reinstate any of their loan or pay off the arrears to avoid the foreclosure. And another significant concern the borrowers face is a deficiency judgment. So if the property is sold at a loss, the borrower may still owe the lender the remaining balance. This is problematic if the borrower is already facing financial difficulties. Okay? Now, a deficiency judgment is really a court order that holds a borrower responsible for the difference between the mortgage debt and the sale of the foreclosed property if the sale does not cover the full amount. So when it occurs, so for example, after a foreclosure sale, if the proceeds are insufficient to pay off the mortgage balance, the lender goes to court to obtain a deficiency judgment. The borrower may be required to pay the remaining balance, known as a deficiency. The availability of these rules regarding deficiency judgments can vary by jurisdictions. And what happens if that order is granted, then the lender can take that order and basically garnish your wages as a borrower, can basically do examinations in aid of executing that order, okay? So find out if you have any money, find out if you have any international assets, and examine the borrower in terms of where their assets are, okay? Words can go on your name too. So it's really key that that if there is a deficiency judgment or there is not enough money to cover, then you need to either do some sort of agreement with the lender, or another thing is you have to be aware that borrowers can challenge the steps you've taken to sell the property. So for example, they can challenge in a deficiency, if you're trying to obtain a deficiency judgment, borrowers can challenge that the property wasn't sold at a high price, right? The property wasn't listed at a high price and so forth. So that's why I stress that as a lender, You need to be able to do what you can to sell the property, whether it's commercial or residential, as at the highest you can, and the steps you've taken to do that. Okay, so for borrowers, there are early warning signs that really indicate financial distress and the potential for really mortgage default. And you should be aware as a borrower of these early warning signs so that you can communicate with the lender. First of all, I always tell, clients who are interested, my commercial clients who are interested in purchasing, let's say, a commercial property, I always tell them, like, listen, you have to ensure you have the money before you even try to get the mortgage, right? So because, a pre-approval of a mortgage doesn't mean that you're actually approved, okay? And lenders, they will find themselves going to court for misrepresenting the fact that a borrower is approved for a mortgage, pre-approved for a mortgage, but then they put an offer on a place and they're not approved, okay? And they now are being sued for failing to close, for breach of contract, right? So it really has a domino effect. So what I usually advise my lender clients is that if you're telling somebody they're pre-approved, you got to also explain to them what that means and get it in writing. That doesn't mean that you're actually approved for a mortgage, okay? So you got to make sure that you tell them and you help them understand what that means. You put it in writing. You have an open discussion with the borrower, and you share that information, because the borrower can rely on the fact that you're telling them they're pre-approved to put an offer on any kind of property they want to buy. Okay, so I'm gonna go back here and just focus on this. So missed or late payments. Okay, so this is the most obvious sign of financial distress. Okay, your late fees. It continues. You fail to make regular mortgage payments. If this continues, obviously, you get the notice of default issued by the lender. You have increased debt, right? So if you're taking on more debt to cover mortgage payments or living expenses, this is a clear indicator that your finances are under strain. This can lead to debt accumulation, and then it becomes increasingly difficult to manage, right? So for example, I have an example here: raising credit card balances or taking on new loans. Changes in income. You have significant changes in your income. Now with the, we're walking on eggshells now with what's going on with the U.S., which I'll explain. Hopefully I'll get to. But anyway, you have the changes of income. You have job instability. These are the common reasons. You have reduced, let's say you had, you reduced hours or business failure, okay? Another area is you have lack of savings. So you have insufficient emergency funds to cover unexpected expenses. You have high to debt income ratio, okay? So a significant portion of your income is going to payments towards your debt. You have frequent borrowing, so you rely on credit cards or loans to cover daily expenses. You really have unclear financial plans. And the biggest thing is that you fail to communicate with the lender, okay, regarding the potential of missed payments. Okay, so for example, if there is a private lender, sometimes private lenders, a lot of the times they take post-dated checks, okay? And those post-dated checks are marked for the time of month. And if you come where something's happened, or, you won't have that for the month, you can call the lender and say, can you not deposit that check today? Can you deposit it next week? And the money should be there. So you should be able to communicate with that consistently with the lender, especially if it's a private lender. You have the property maintenance issues. One, the inability to afford necessary repairs or upkeeping your property, residential or the commercial. Economic changes is one, like where there's the economic downturns. Just the other day, Bank of Canada did a news conference and indicated we might be heading into a depression, right? So that's something you really need to start thinking about now. And another area is really health issues. If you have health issues, this can lead to increased expenses and reduce income. So really, for me, my main thing is that it's essential as a borrower. Like, my main thing is what I want to get across is communication is key. It's essential for a borrower to act earlier, okay, when they start experiencing these warning signs. You should be speaking to a financial advisor, exploring your refinancing options, and you should be contacting the lender directly, okay, to prevent really the issue from escalating into a mortgage enforcement. You know, that is another, you know, that's very, very important. Some of you will have a good relationship with your clients. Okay, if you have a good relationship with your clients as a mortgage broker, you're going to consistently, even though your clients, you know, secured a mortgage, you're going to consistently be, you know, checking up on them. That's what you should be doing. That's, you know, something I recommend. Now, another area that you guys need to all think about is bankruptcy. Bankruptcy, as I said, is governed by the federal laws of Canada. If the borrower declares bankruptcy, it does provide the borrower relief, and it complicates matters for lenders. Okay, declaring your bankruptcy triggers an automatic stay, which means it halts any foreclosure proceedings and any collection efforts by creditors, including the mortgage lender, right? If you do declare bankruptcy as a borrower and an automatic stay happens, a bankruptcy trustee is appointed to manage the debtor's assets. The trustee assesses the situation and determines how to handle the secured debts like mortgages. Okay, mortgages are secured debts, meaning the lender has a claim to the property. The borrower must continue making mortgage payments to keep the property. If there is significant equity in the property, okay, the trustee may sell it to pay off the creditors. However, the borrower can negotiate to keep their home or their property, whether commercial or residential, by paying the equity amount. If the borrower cannot continue mortgage payments, the lender may seek court permission to proceed with foreclosure after the stay is lifted. Okay. Now, insolvency and mortgages. Insolvency occurs really when a borrower cannot meet their financial obligations. This leads to a consumer proposal, right? The borrower must continue to make mortgage payments unless the property is surrendered or sold. It allows the borrower to negotiate a repayment plan to creditors, okay, including the mortgage lender, while keeping the property. Both bankruptcy and insolvency negatively impact the borrower's credit score, really affecting their future borrowing ability, and the borrower remains responsible for ongoing mortgage payments unless the property is surrendered or sold. Okay, so communication again is key, right? You must communicate as a borrower with the lender, and the lender must communicate with the borrower to really explore options for retaining the property. You need to seek legal advice, right, which can help you as a borrower, and as well as the lender to both understand your rights, your rights and your responsibilities. And overall, bankruptcy does provide relief for unsecured debts. It requires careful handling of secured debts, like mortgages, to avoid losing the property. Okay. Now, an area I do want to turn to and look at is basically one very, very much, it's a very, very important area, okay? We are now we are really walking on eggshells in Canada, okay? With the tariffs potentially being imposed from, the U.S. on the U.S. side, it's going to be very difficult. Yesterday, Trump said he's going to delay it for another month. But again, that adds a lot of stress on our economy and where things are headed, right? If there are changes to the trade policies, right, it does fluctuate it does result in fluctuating interest rates, okay? It does have increased economic uncertainty, and it does have shifts in consumer confidence. This all can really affect the real estate and mortgage landscape and mortgage conditions. Okay, now we're going to briefly go through this slide. It is going to be available after on YouTube. Okay, so the impact of U.S. trade policies on Canada, Canada's mortgage landscape, as I mentioned, can be significant. It affects both lenders, borrowers, and the real estate market. Changes in U.S. trade policy does influence Canadian interest rates. Tariffs or trade barriers may lead to economic uncertainty, really affecting rate decisions by the Bank of Canada. It can lead to job losses. It does affect the Canadian exports, right? Really affecting economic growth. And lenders at this point may tighten their credit conditions in response to this increased risk. And it does really, the U.S. trade policies that, they're talking about enforcing can really affect cross-border investments, right? Which it really influences the ability of capital for Canadian lenders. For borrowers, the economic impacts from trade policies, as I mentioned, can affect employment and income levels. It does influence borrowers' ability to afford mortgages. Borrowers may face variable interest rates, which affect monthly repayments and overall affordability. And the trade tensions can reduce consumer confidence, right? Impacting decisions to purchase or refinance homes, okay? The economic uncertainty also has an effect, like I said, on the real estate market from trade issues, which can lead to fluctuations in property values, affecting both buyers and sellers. New construction, right? New builds, cost of materials can go up. The projects, which can affect projects. Again, the demand and supply can both, it can have issues, and it can influence our immigration and foreign investment which impacts our housing demand. And areas that are heavily reliant on trade with the U.S. can also experience more pronounced effects, okay, which does lead to regional disparities in the real estate market. Now that we looked at, so as you can see, mortgage enforcement is force of sale mortgage enforcement, if you follow the steps and you follow the statutes, they're pretty easy they're pretty straightforward. But again, there's a lot of things that can come up, like it really depends on your facts and what the borrower is saying, okay? Now we're going to turn to navigating litigation and alternative dispute resolution. When to litigate versus when to settle. This is my, the favorite part of my webinar, because I love litigating and negotiating and doing arbitration and working out settlements. And really, I love making it I'm very personable with my clients. So I'm very, their issues matter to me, whether that's a lender trying to enforce, a private lender, a mid-sized lender trying to enforce, the mortgage, and the borrower as well. So litigation, I would say, typically is seen as the last resort. I've seen, litigation started by lenders, and their statements of claim is atrocious, okay? I've seen these things in court, and I just, it's just the way the things are written and the way the things are done. There isn't that deep dive into the actual issues, into the actual steps the lender's taken, into any of that. And I think for me, it's more of that, I want to protect my lender, I want to protect my client who's a lender or my client who's a borrower, by really, ensuring that I have all my facts. Because the last thing you want to have is decisions by court, the courts basically saying you're ineffective as legal counsel, okay? So let's go quickly through this. Again, when to litigate if there's serious disputes. So there's a case I'm going to put up on, I'm going to refer to. We're going to put up on the chat. It's called Gold and Camera. It's a 2024 ONSC case, reference 6706 for, it's available on CanLII. I do recommend you look at this case. It's a great case, okay? It involves a mortgage enforcement case. There are serious disputes. It involved, there was ineffective counsel found. There's a lot of stuff in there. It was a number of mortgages. I do recommend you do review this case. It's a great case as a lender and both as a borrower. So, serious disputes, right? Is there a significant breach? Is there things like fraud? Is there things like misrepresentation? Is there things like a major contractual violations? Litigation may be necessary to settle the matter. In this case, Gold and Camera litigation was necessary. Deficiency judgments. If the borrower challenges the deficiency judgment or the sale price of the property, litigation may be required to determine whether the lender is entitled to recover the shortfall. Complex cases, okay, such as disagreement over mortgage terms, valuation disputes, or contested rights to the property, the court may be the best option for a final binding decision. Now, when to settle. Financial concerns, okay? A lot of borrowers who are going through this process, they may be under financial constraints and they can't hire a lawyer, okay? Litigation can be expensive if both parties are open to negotiating. Settling early through mediation or arbitration can really help avoid the unnecessary legal costs. If you want to preserve the relationship, so if the lender and borrower have a desire to maintain a relationship, for example, the borrower is seeking to pay off the debt or work out a solution, settlement can offer a quicker and less adversarial path, and you want a faster resolution, okay? It can take months or even years. If both parties are willing to negotiate a settlement, this can be resolved issues quickly, okay? Because litigation is quite lengthy and at times can be expensive and so forth. So the takeaway here, litigation may be the definite solution, but mediation and arbitration and working towards a settlement are often faster and more cost-effective. Now, I've listed here the benefits of mediation. Again, it's confidential, so the last thing you want as a lender is basically the court to say that you're not credible, right? And it's not great to have that out in public, especially in a case. So the mediation will basically afford you confidentiality, the flexibility to have it done as soon as possible. It's a faster resolution, and it's really assists you in really preserving your relationship with the borrower. Okay. Now, how does mediation work? You get a neutral mediator, so the parties can select a neutral mediator who facilitates the communication and the negotiations. You put together a brief with all the documents you intend to rely on. It's confidential. You attend the mediator's, either you attend your lawyer's office where you could do it virtually, or you attend the mediator's location, or and so forth. I like to do these in person and with my client present, whether my client's present in my office. That way we can have, more of a private conversation versus over Zoom, but you can do it over Zoom. An agreement as well. So you can have an agreement drawn up while you're in the middle of mediation, during mediation, and the parties can sign it, right? And then you can go to court to enforce that agreement if you need to, okay? It's an excellent option for both parties to compromise and really avoid the lengthy, expensive legal battle. Arbitration, and just to let you guys know, a mediation and arbitration are usually, they can be done by a former judge. So former judges are usually mediators or arbitrators or seasoned lawyers like I'm talking about. They've been in this industry for 40 years. So if mediation fails and is not an option, arbitration is another form of alternative dispute. Again, it is binding decision. It's confidential. There are contractual agreements before you enter the arbitration. It's faster than litigation. Typically, you have a clause for alternative dispute resolution in your mortgage agreement. So that means the arbitrator has jurisdiction to deal with the issue. If not, it has to be on consent. It is like going to court. There are hearings and there are statements provided and evidence presented, including expert evidence, but it is private. There are binding decisions. It is quicker. I wouldn't say it is cheaper than going to, than having the matter drag on and having to go to wait to go to court for longer periods of time. Now, I want to just, while we have a little bit time left, I do want to go through what, the role of mortgage enforcement lawyers. Okay, so when you get a mortgage, when you're borrowing money from a lender to purchase a residential commercial property, you have to understand that you have a solicitor. That is your first person that should be telling you what your rights, responsibility, and obligations are as both a borrower and a lender. Okay? Now, what needs to happen is that sometimes solicitors are working with institutions like big institutions like CIBC, RBC, Scotiabank, and they are acting for both the lender and the borrower. Other times, if they're smaller, the lender will have their own lawyer who will produce the documents related to the mortgage, and the borrower will have their own lawyer to review those documents. It is imperative that if you're a solicitor and you're watching us today, that you really put it in writing exactly what the rights and responsibilities are for the borrower and their obligations when they're taking on this mortgage. It's not enough to go through the documents with them and have them sign. You really have to explain it to them, because you risk being sued for negligence, okay? You also risk the fact that the borrower might say, I didn't know that was the case, and so forth. So it's imperative that you do that in the get-go. If not, right, if not, and this still proceeds to court, you're not going to be named as a party as a solicitor because you have everything, but you still, as a borrower and a lender, you still need to use a lawyer to help you when you're going through mortgage enforcement, navigate the legal process. You want, for the lender, you want a mortgage enforcement lawyer to help you enforce your deficiency judgment, right? We do this by we're helping recover the remaining debt. So we've done, we've taken part and done, enforcements, okay? You need representation in court. You want a lawyer who is going to represent you ethically, okay? There are a lot of lawyers out there that are not, in how they proceed with things. Then for borrowers, you have, protecting your rights as a borrower, defending against deficiency judgment. Like I said, can help the borrower basically challenge the amount owed, contest the sale price, or argue for reduction in the amount recovered. And that could, there are, for example, interest rates, right? Are they criminal? Are they, do they hover around that? So all that stuff, is something that we can look at, and they can negotiate with the lenders. Again, another thing that a lawyer can do for a borrower is really question the payout statements, right? So a private lender can provide payout statements where legal fees are, let's say, $20,000. But it's not necessarily should be $20,000, and the borrower's legal counsel can ask, can you give me a breakdown of these amounts? Okay. Again, you need to we assist in helping lenders take preventive strategies, right? So, lenders, you should have clear documentation and contracts. So lawyers can help you ensure that the mortgage agreement and any related documents are well drafted and are legally sound. This includes clear terms of default, the rights of both parties, and detailed provisions of foreclosure or power of sale. You need to look at risk mitigation, okay, by getting early legal advice. We can assist you in pre-screening borrowers and offering refinancing or restructuring options before default occurs, okay? For borrowers, like I said, understanding loan terms and taking steps to basically deal with this early on, okay? Now, when to involve a lawyer, again, like I mentioned. So I mentioned why lawyers are important. Now I'm going to just provide a little bit as to when to involve a lawyer. If the borrower is in default and is not responding to notices, it's a good idea to contact a lawyer early. The lawyer can help ensure all legal requirements are met before proceeding with the power of sale foreclosure and reduce the risks. If there's a possibility of deficiency judgment, you need to involve a lawyer in to help you with that. For example, there might be other properties that the borrower has. The borrower might have assets overseas. Like, there's a whole bunch of stuff that you need to consider. For borrowers, if you receive a notice of default or are facing foreclosure, contact the lawyer immediately. And if the property has been sold, you can contact. It's important to involve a lawyer to challenge the deficiency judgment if it's coming. Okay. Thank you guys for joining us today. I do appreciate you guys coming today on this gloomy winter day, which I thought would be nice. I thought we would have nice sunshine like yesterday. Please feel free to provide your questions. I will do a brief question and answer period. I do apologize if I went too fast. There's a lot of material to cover. I just wanted to ensure that the basics are there. If you do have any serious concerns, or you need to, and you want to chat more, you can book a paid consultation with me. Where I'd be happy to chat with you, both as a lender and borrower, and we can have some lengthy discussions. Okay, so I believe I have my first question here. How do we actually proceed to sell the property? For example, the locks, house, deed, etc. Now, you basically you have to. You need to get, once you get the force of sale documents, and you need to go to the basically you need to start the process. If the borrower is giving you difficulty, you need to get the court and a sheriff involved. Okay, so that you need to do all of that. It is a process, but the first thing you need to do is this is why lenders tend to bring both a force of sale and a statement of claim together. Okay, the court can order. You have an order in your hand. You then go to the property, you then bring a sheriff, you exercise that order. Okay, so there is a process, there are steps that you have to do after, but the first thing is you need to follow the steps first in the beginning. So thank you for the comment. Do lawyers tend to work with brokers in aiding borrowers facing power of sale? With brokers in aiding borrowers. Okay, so yes, if you, like, what I mean by that is, if you as a borrower have a lawyer, okay, and you're most likely you're getting this default, you're getting this notice of default and steps to be taken, a lawyer can get involved with speaking with the lender. Okay, a lawyer can get involved with speaking with the lender, because this is the thing. You need that protection. You need to ensure that the facts you're presenting, both either as a lender and as a borrower, are proper facts and proper discussions, right? So it's always imperative that if you're going through this process, there is an opportunity for you to still save your property, still save your commercial building. And I've seen it, and the borrower's lawyer, the lender's lawyers are willing to work with you. Okay? So what you need to do is, obviously you need to retain a lawyer. That it can be a little bit, there are, the retainers, you have to pay the retainer and so forth, but you need to be able to have that someone supporting you. Okay? And if you're, sometimes as a layperson, it's very, very difficult to do it on your own. I've held a case where, I assisted, a client from having their commercial property, sold by, sometimes you need some time to get refinancing, right? So sometimes you need time, and sometimes you need the lawyer to discuss with the lender's lawyer, like, listen, we know you're owed this, we're taking these XY, you're taking all these steps to basically get what you get, provide you the money you need, right? So again, like I said, you have to be able to have the lawyer who has those skills to negotiate and the experience to negotiate on your behalf. And as a litigator, and in my office, we're all litigators. We're seasoned litigators. We work on complex matters. We understand the case law. We can interpret the case law. We understand the statutes and how they're applied. We can assist anybody, whether you're a lender or a borrower, because we know what the courts are, how they make decisions based on the history of the case law. Okay. In power of sale, can locks be changed if the property is occupied by the owner? locks can be changed, but again, like, this is why I'm saying, like, if you give a notice of sale, okay, the borrower has 35 days, right? Like, that's what I'm saying. Like, the borrower has a lot of rights. So the borrower has 35 days to essentially have discussions before the sale proceeds, right? To essentially rectify the situation. Okay, so once you issue the notice of sale, it isn't just issue notice of sale, put the locks. You should be waiting 35 days. If once the 35 days is completed, then you begin the process, right? Because within that 35 days, the borrower can challenge, right, the notice of sale. The borrower can pay. The borrower may be taking steps to get more financing and understands that these are additional costs that they're going to have to pay you as a lender. But again, as a lender, I want to drill it in your minds. You need to basically ensure that you're acting fair and ensure you're complying with the legislation. Okay, you do not want to be seen, even though the borrower might be sophisticated, the court finding the borrower isn't sophisticated in investments of this magnitude, and you don't want the court to make negative findings against you because you have a higher footing than the borrower. So for me, it's very much important that you do this properly, right? And we have that discussion together as to what you need to do to accomplish getting what's owed to you, while still being, while coming to court with clean hands. Okay. Is there any other questions? If not, thank you so much for joining us today. I really appreciate. I do recommend that you reach out to us. We will be hosting another webinar next month on breaches of contract. We will be sending you information regarding that webinar. Thank you again, and we look forward to hearing from you. Thank you and take care.